Welcome to the ADR Across the Globe podcast with Dr. Chinwe Umebolu and Mr. Tony Guys. The primary aim of this podcast is to contribute to the civic discourse on how ADR and digitization can transform the lives of citizens caught in the web of justice backlogs. And this week, we're sitting with Mr. Andrew Tweeddale. He is a lawyer and an accomplished writer of both fiction and non-fiction books. He co-authored the leading arbitration textbook with his wife, Karen Tweeddale, Arbitration of Commercial Disputes, English and International Law and Practice, first edition, and his second edition with Associate Professor of Law, Dr. Masood, Ahmed, who is a solicitor and lectures at the University of Leicester. His research has been published in various international academic journals and articles. It's such an honor to have the both of you on the show. Mr. Sherry Noun.
Thank you, Chinwe.
Thank you very much.
Yeah, so I'll be handing over to my co-host, Mr. Tony.
Yeah, so both wonderful to have you on the show. Great to have you here. Important book. I was just wondering if you could give us a brief introduction to it. Perhaps you could explain whether you found the writing of it, the co-writing of it, working together, and actually getting on with this. It's quite a masterful work. I had the opportunity to look at an early version, or close to final version, last year, as you both know, and wrote a little review of it. It is quite a comprehensive work, and I just wondered whether you both found it an enjoyable experience or simply hard work.
Masood,
Andrew, do you want to kick off, because you're the original author of the first edition, so you can start up an argument.
Yeah.
I have to say, writing that book, I blame my wife, Karen. She came home with this idea about writing a book and found a publisher while she was a lecturer at the University of Westminster at the time, and came home with saying, "Oh, Andrew, by the way, you're writing a book." So I have to say, it's an interesting experience. This one took a lot of time, simply because we'd virtually written the book, Masood and I. We met when Masood contacted me and asked whether I was going to update the first edition with my wife. I told him that no, I wasn't. He then suggested that he do it. I then sort of had a chat to him and said, well, shall we share it? And that's what we ended up doing. But it was an interesting writing experience, simply because we'd virtually written the book when the Law Commission came out and said, we want to review the Arbitration Act.
Yes.
So we phoned up the publishers, or we emailed them and said, look, we have a little bit of a problem. The Arbitration Act is going to be reviewed, and knowing what timescales are for publishing a book, we don't want to actually issue one that's out of date before it gets to print.
Yes.
So they said, well, hold off. So we did, and the Law Commission duly issued 3 reports, or two reports, wasn't it?
Yeah.
And anyway, so they came out, and we updated the book with the proposals, and at that time the Conservative government was in. They decided they were going to adopt the book, adopt the Law Commission report, bring it into a bill, then into a statute, and halfway through that process, the Conservatives were kicked out of power and Labour got it. So it was all put on hold again. Labour said they were interested in updating the Arbitration Act. So we duly got back to our computers and started writing again. And finally, they decided to review the bill that had been put forward, making some small but important changes. And finally, it turned into an act that took 6 months then, from February 2025 to August 2025 to be implemented. So we kept on having to go back and review it. The law changed, I think, quite considerably over the 4 years that it took to get from the Law Commission to onto the statute books.
Yeah. So just to add, I mean, my perspectives and sort of experiences. I mean, I think one of the key things here was making sure that the two co-authors connect and have a sort of a similar approach and a vision on the book. And I think that was great between Andrew and I, because Andrew's coming from a very practical perspective, although he's done some academic work in the past and he'd written various academic papers, and I'd been in practice many years ago, so I'd kind of detached from that world. But I was engrossed in the academic world, and a lot of my research is based on doctrinal studies of case law and how judges think and how the case law develops, and trying to extract from that what we can learn about arbitration. So I think the two sort of authors came together quite nicely there, because they brought both perspectives in a very focused and strong way in the book. So that was one thing. The other issue was, as Andrew's already touched on, is the developments. I mean, in arbitration, the case law develops very rapidly. Whether it's actually taking the law forward or just confirming established principles, you still need to be on top of whatever the commercial court of the High Court is saying and doing, because obviously, as you know, that's the main court that has jurisdiction over arbitration matters. But the other interesting thing I noticed was, and Andrew did as well, is how many cases are actually going to the higher courts, so the Court of Appeal and the Supreme Court, which was unprecedented over the last 4 or 5 years, because usually arbitration matters tend to stop at the commercial court level. But a few interesting ones were going all the way to the Supreme Court, including the Enke case and the Halliburton case on bias in arbitration. So it was really interesting and an exciting time to actually write as well, and picking up all that case law. And also the last point I'll make is on this issue is looking at the 2025 Arbitration Act as a result of the reforms which Andrew's just been talking about. One of the interesting things about that was, when writing, was sort of trying to understand and trying to articulate how judges are going to approach the new provisions, and trying to give guidance and sort of a steer to practitioners and academics and scholars in the area as to where the law is likely to develop and how it's likely to go forward. And that was interesting, because you had to look at the previous case law, the present case law, and trying to come up with principles and ways forward as well. So I think all of those elements came together quite nicely. But I think the key thing is that both authors need to connect, as I said before.
Yes, well, you obviously did connect very well from what I can see from the product. And perfect timing as well, really, with so much activity going on. Typically, arbitration is a fairly static field, well understood principles, and then all of a sudden, at the same time as you join forces, the field is not quite upended, is it? But nevertheless becomes quite lively. And I mean, the first edition is one of the most frequently cited authorities in the field of, as you know, arbitration case. Really interesting to see how the second edition fares. I'm sure it will be at least as frequently, if not more so, given the views you're expressing on the way forward. But Chinwe.
All right. So I would just ask for Professor Masood to sort of give us an overview, summarize, because we don't really have time, of the second edition of this textbook. And of course, Mr. Andrew can also add if we still have time for that, but it's just to summarize the book itself, and then we can ask subsequent questions afterwards. Thank you.
Yeah, that's fine. So the first edition, as we explain in the introduction to the second edition, had a very interesting and detailed chapter on ADR and ADR procedures, as well as then going into detail on arbitration. So the first edition covered mediation and other forms of ADR, adjudication, for example. But when we started to write the second edition, the feedback that we got from the reviewers was, look, we should get rid of that part of the first edition and just purely concentrate on arbitration, and that's what the second edition essentially does. And what the second edition does is it follows the previous edition, and it focuses on English arbitration. And the first edition covered international arbitration, and then it had a second section on English arbitration. The second edition now just focuses on English arbitration, and it follows the structure of arbitral proceedings from beginning to end, and it covers all the provisions of the Arbitration Act 1996. It covers all the provisions of the new Arbitration Act 2025. It incorporates at the beginning a section on AI, artificial intelligence and technology, which we'll come back to later. And it incorporates the guidance that's been given by various arbitration institutions and centers like the ICC, the Chartered Institute of Arbitrators. And it also incorporates the latest English case law on the use of AI, and here I'm referring to the leading divisional court case of the Haringey case, in which the court provided guidance on the use of AI in court proceedings, civil court proceedings. So it covers all those recent developments as well, and we draw sort of lessons to be learned from the civil litigation jurisdiction to arbitration as well. So we give guidance and sort of advice on how AI should be used and what the responsibilities on practitioners should be. So the book reflects the latest developments on those issues, as well as the case law and on legislation. Andrew, do you want to add anything to that?
I would just say that all through the book, what we've tried to do is follow a structure where the first chapters are the first parts of the arbitration, looking at things like the applicable law, the law of procedure, commencing an arbitration, and then going through the arbitral process. So it's taken a very sort of logical structure in the book, similar to the first edition, and very much on a English law basis. So there are a number of quite detailed sections within the book, which I think most practitioners are going to find very, very helpful.
Thank you.
So last point to mention is obviously we've incorporated international perspectives as well. We shouldn't forget that, and we do reflect on leading arbitration jurisdictions like France, for example, Singapore, Hong Kong, and we reflect some of the latest developments there as well. So not just predominantly it is English arbitration law and practice, but we also incorporate international perspectives as well.
I mean, in particular, I just thought that on that particular point, Masood, insolvency, for example, we dealt quite significantly with insolvency and arbitration, because there's been so much on it from the Privy Council, the House of Lords, and the leading courts in Hong Kong and Singapore. So, we didn't think when we wrote this, Tony, that we could sort of omit the international perspectives completely.
Yeah.
They gave a nice rounded view of the subject.
Yeah.
Yeah, I mean, it's a vast subject which you've covered in including the index, 629 pages. I mean, it's going to be in my view anyway, a must-have for any arbitration practitioner, wherever they are, to be quite honest, because England is the premier jurisdiction, is it not, for arbitration? Well, there are plenty chasing that crown. You also touch on technology as well, which is, I mean, the vast sweep of this book is very impressive, and on AI. We recently, Chinri and I recently interviewed Aaron Gothelf from the AAA about their AI-enabled arbitration, or arbitrator, AI-enabled arbitrator tool that suggests possible awards. Perhaps you could touch on your views about the use of technology in arbitration, how it's growing, perhaps even, if you dare, suggest.
Sorry, Tony, I didn't hear your last comment.
Yes, I said you touch on technology. Perhaps you might dare to suggest where technology might be going in the arbitral context in arbitration.
I'll take that one. I mean, technology has been used in arbitration for many years, and even before COVID. But COVID obviously accelerated the use of technology to adapt to the circumstances, and it's been used for virtual hearings, for example. But COVID obviously accelerated that. So now we have cloud-based storage of documents, for example. We have the use of e-disclosure, video conferencing for interim and final hearings. And I think one of the things to note about the use of technology and AI in international commercial arbitration is that it essentially rests on the fundamental and the most important principle in international commercial arbitration, which is the principle of party autonomy. So if the parties wish to use technology and AI, generally they are allowed to do that, and clearly they'd have a conversation with the arbitrator, but that principle of party autonomy prevails, and that's something that the Law Commission also touched on, because there was a debate around whether the Arbitration Act 1996 should make provision for the use of technology. Should there be a specific section under the Act to say yes? But I think the Law Commission came to the right conclusion, because what they said was, look, the 1996 Act is designed in a way in which it moves with the times. And the opening provisions to the Arbitration Act 1996, Section 1, A, B, and C, talks about the principle of party autonomy, the need to uphold the principle of party autonomy, and for the courts to have a limited role in arbitration. So they said, well, no, we don't need a specific provision, and the Act accommodates for the use of technology. But just in terms of the use of AI, where is it being used, and where are we going to go with it? I mean, AI in document review and disclosure. Tony, you know already from the practice in the commercial court, in the business and property courts of England and Wales, this has been used in trial for many years, and now forms part of and has been endorsed and reflected in the civil procedure rules for disclosure. And judges actively encourage the parties to use this because it saves time and cost and money. And that's essentially where the policy behind the use of technology and AI in arbitration is the same. You know, the use of these tools is going to tackle that perennial problem of how expensive arbitration is. And Andrew will talk a bit more about costs in particular. So AI in document review, just as in the courts. Also AI assisted legal research and drafting of documents. We already know that AI has already been used by practitioners, by arbitrators, by judges to carry out legal research, to summarize case law, legislation, for example. And that's being actively used in arbitration as well as drafting submissions that are going to be put to the arbitral tribunal. Also AI in translation of documents in cross-border disputes. Now, the nature of international commercial arbitration is such that you're going to have parties from different jurisdictions speaking different languages, most likely, and therefore here I think AI can really assist in reducing the cost of human translators, like as in the old days. You'd be spending a lot of money on getting somebody to translate masses of documents, but we can get rid of that, and that's something that is being used in arbitration, and also data analytics and predictive tools. Using AI to identify certain trends in arbitration practice and procedure, in how strong or weak certain submissions are, and using that type of AI tool to set out strategic decision making around arbitration as well. So lots happening in arbitration. In terms of the technology side, I've already said virtual hearings, video conferencing actively being used, especially after COVID, cloud-based platforms and electronic case management as well, making the arbitral process more efficient and more cost effective. And just to touch on one last point before I hand over to Andrew, we've had lots of guidance from various arbitration centers and institutions, and just to mention just a couple. The ICC, for example, have issued their report on arbitration and ADR and the use of information technology in international arbitration. And that report itself starts off by encouraging parties to use technology, and it emphasizes the cost effectiveness of using technology in arbitration, because arbitration is so expensive. We also have the Chartered Institute of Arbitrators guidelines on the use of information, on the use of AI and information technology 2025. Again, that sets out sort of some guidance on the importance of AI, but also some of the risks around the use of AI, and emphasizing the fact that AI shouldn't replace human decision making, and that's a debate that's been happening. Yeah. So that's a debate happening across ADR procedures and processes, as well as the courts.
Sorry.
Yeah.
Okay.
I
wanted to ask a question. So, what constitutes fair hearing in AI-assisted arbitration?
That is a very interesting and controversial issue and question, I think, because from my understanding and knowledge, I haven't come across anything that's specifically dealing with very high, complex and cross-border arbitrations where the arbitrator has been replaced in any way, or where the arbitrator is actually using AI to do the decision-making process on the merits of the issue or the substantive issues. But AI is obviously being used to automate certain procedures and processes. It's being used to help with summarizing documents. It's being used to schedule hearings and getting people's availability, and also being used to even draft orders, but which are being interim orders, which are being checked and double checked by human arbitrators. So I think here, it's a really interesting question, and I think this is where the guidance that I was just talking about is really important for the arbitration community, because all the guidance that's been issued, the Silicon Valley guidance, the Chartered Institute of Arbitrators, the ICC, for example, they all try to highlight the risks and benefits, and then try to explain where the balance needs to be struck so that we protect independence, impartiality of the arbitrator, and confidence in the arbitral process, but at the same time utilizing some of the benefits around efficiency.
I would add that just going back to first principles, the arbitrator's decision-making powers are non-delegable.
Yep.
So, for example, we've had cases where tribunal secretaries have become involved in more than just secretarial work, and the courts have looked at that and said, no, tribunal secretaries can't get involved with drafting the dispositive parts of the award. Similarly, AI is just a tool, and I don't think at the moment the courts would allow, unless the parties expressly agreed, that the arbitrator's duty to write the award and its reasoning could be delegated to AI. Now that may change in the future, but at the moment I think that's where we are.
Thank you.
Yeah,
so
well,
very
we have
much.
done. Yeah, sorry, Chinwe, go ahead.
No, Mr. Tony, carry on. We just have 3
Yeah,
more
I was just going
minutes.
to say the pace of technology progress is only going to accelerate, it seems to me, with agentic AI, and then we have the prospect of quantum technology upending everything, which is, though I don't think fanciful by any means, given last week's announcement by the Chancellor of the Exchequer of £2.4 billion to be invested in quantum technology projects in the UK. So it's only a matter of time, really, before we get to another leap forward. Another leap forward. My view about the use of AI is that really it only works in ADR context, and I include for this purpose arbitration. If the AI is being trained on a closed data set, the danger with the large language models is that they're just too low, bringing in everything, and then they get into this vicious cycle, which has a particular name which I cannot remember at the moment, but they simply regurgitate things they have learned on the internet, which then goes onto the internet, from which they learn again, and so it's reinforcing the possible mistakes. That's what interests me about the AAA's project, which is construction arbitration, as you know, and it's based on their 30,000 case data set. Chinwe, did you want to ask any further questions? I just have.
Yeah, I wanna, because Mr. Andrew, I want you to touch on costs. What's the story so far on costs? We have 1 minute 25 seconds. Thank you.
Okay, I will do this quickly. I think costs are something that the arbitration community must look at. We've had William Rowley, Casey, and others saying we need a reset in international arbitration because the costs have got so large that we have to look at other ways of resolving disputes. And I do think that the Arbitration Act 2025 went some way to helping, but not nearly enough. It's got summary procedures or summary dismissal of claim procedures in the new Arbitration Act 2025 at Clause 7. That's going to help. Case management is probably, though, the main thing that will reduce costs. Remote hearings and technology, as Masood rightly touched on, will have a cost consequence, but all these things, I think, are just chipping at the edges. I think there needs to be some review